let's make a start. So you should see my slides on the screen. And firstly, just a little bit about us. Some of you I can see are familiar faces. I recognise the names as well. And also sometimes I email people all day, and it's actually nice to see some faces. So I'm looking at some like Heather. I'm looking at you. You're smiling back because we were just emailing the other day. So it is nice to see some faces. So about us. So we are a law firm, we're regulated by the SRA, but we just specialise in HR and employment law. We also do health and safety, we do training now. Anything that you need for people management, we are your one-stop shop. Particularly, we've got our watertight package that I'll talk to you about, but in terms of what I do lots of things like redundancies, 2Ps, restructures. We support you through all these very difficult times. It's great to be proactive with our clients in terms of planning ahead and putting in place policies and plans going forward, but also sometimes we recognise that things creep up on us, and there's nothing worse than coming in and a claim's landed on your desk, a grievance, or a manager's reported to you that they need to do a disciplinary. We can help you do the firefighting. Firefighting is one of our specialities. So in terms of industries that we work for, we're across the board. We work for so many different sectors. These are just some of the specific guides we've created for business owners, charities, hospitality, law firms. But there's not really a sector that we don't work with. So how can we help you? Or after today, you might think, oh, I could actually do with a bit of help with my HR, and particularly holidays, because this is not an easy area. So we offer a watertight package. So watertight is our outsourced HR. It's a retainer package. We basically support you in all your HR needs. We help you with your letters. We help you with just general guidance day to day. Oh my God, this has happened. What do I do? An employee's done this. How do I deal with that? We are on standby basically for these issues to talk you through them. We also do your contracts and your handbook, so we take all that stress away from you. You know that you're up to date. And the biggest thing that we think is a huge selling point with our package is it's obviously supported by the legal advice, because at the end of the day you can't have HR separate to legal. Employment law, they're all, to us, they're one and the same thing. And if you're not fully aware of employment law, you really shouldn't be practicing in HR, because you're going to end up in a tribunal at one way or another. So we package everything together for you. So if you do want any information on that, there's lots of information on our website, obviously, as well. Maybe drop myself or Ellie an email. We can answer some more questions, or give our office a call and we can just talk you through it. So what we're going to cover today, we're going to go over, so it's all holiday pay, isn't it? Holiday pay for part-time workers. Firstly, I want to actually have a look at what the working time regulations say. Then we're going to have a summary of the Harpur case, which is the case that has caused all the problems. We're going to look at who this case applies to. Key question, how are we going to calculate holidays going forward? Can we still use the 12.07% method? Can I still pay rolled up holiday pay? I'm going to answer. Also going to answer additional one about whether this applies as well to contractual holiday entitlement as well as statutory. Before we go into that, I did promise some people I'd just do a little bonus section on bank holidays and next Monday. So that is separate to the Harpur case. This has obviously arisen because of the Jubilee, not the Jubilee, sorry, we had the Jubilee. Now we've got the Queen's funeral. They have issued or declared Monday to be a formal bank holiday, and the amount of people that have said to me, well, it's a bank holiday, you are entitled to it off, you are allowed it off. And I think these are people that know what I do as well for a living, and they've still told me that I'm wrong. But essentially the question of whether you have to allow your employees the day off on Monday, a lot of it comes down to your contract. So the basic positions are that an employee is entitled to 5.6 weeks pay. or holiday leave, sorry, the working time regs does not specify whether of that includes bank holidays or not. That is your decision as an employer. So obviously we have hospitality where they work all year round. Those types of workers don't get bank holidays. So that's why the regulations don't specify whether bank holidays are included in your 5.6 weeks. So as a standard, no, not everyone is entitled to bank holidays off. So we then look at your contract and we see what that says. So if your contract says, for example, you are entitled to 25 days plus bank holidays, I would be reading that and interpreting that to mean that they would be entitled to this additional bank holiday. Because it's an official one that's been declared, I'd be saying yes, it's going to be included. If the contract says 25 days plus usual bank holidays, or 25 days plus 8 bank holidays, then contractually they wouldn't be entitled to that bank holiday, and it would be up to you as an employer to exercise your discretion as to whether you want to honour that holiday. What we found is lots of employees are honouring the holiday regardless of what the contracts are saying. Some are taking a bit more of a middle stance in terms of that they're closing for a small section of the day. Or like, for instance, we're actually working on Monday, but we're going to be working from home. We are allowing everyone to take time to watch the funeral. But if you want to take the day basically to use it for anything else other than the funeral, then you need to be booking a holiday. That's been our approach anyway, but we're mega busy at the moment. And you know, it's a difficult decision. And this is I'd say it's not a unique situation because we had the Jubilee. And I do think now we are going to see, well, it's going to be interesting to see what they do about the coronation, how long Charles is going to be around, you know, when are we going to see another one of these? I'm not being pessimistic or anything, but this is going to be an issue that I think is going to crop up more and more with these sneaky bank holidays coming in. So I hope that's answered some of your questions on that. I have done a blog on it, which is far more detailed than what I've just gone through. So please have a look at our website. And also, if you need a bit of help of how you're going to communicate that to your employees, the decision. I know we're a bit late in the day now, it's a Thursday and we're looking at Monday. But if you do need any assistance with that, just let us know. So moving back to the Harpur case then. So firstly, what does the working time regulation say? So we've had these regulations for a long time. So what is that telling us that we've got to do? It tells us that employees are entitled to 5.6 weeks leave in any leave year. We are told that we can prorata that leave for those that start partway through the year and leave partway through a year. So that's when it's telling us we can prorata. We know that we're entitled to a week's pay in respect of each week of leave. And we've got some guidance in terms of what a week's pay is. So for a regular or a worker that works regular hours, it's a lot easier to calculate. So we know that we can look back at what they've earned generally over the last 52 weeks, but it's going to be, if they're paid the same every month or every week, we know what we're dealing with. Only thing we've got to be careful of is now that we know that we've got to include things like regular commission, overtime and bonuses, as I said, if they are paid on a regular basis. So it's not a clear-cut situation with those, but if they are paid often, we need to be factoring that into the pay. Then we've got irregular hour workers, and we recently had a change in that. We used to calculate that over pay over the last 12 weeks. We now calculate it over 52 weeks, and we exclude any weeks where no pay, let's use a typo there, where no pay or statutory payments are received. We ignore those weeks. And for every week we discount, we have to go back a further week, up to a maximum of 104 weeks. So one thing I want to point out here is that we've got two separate issues here. We've got leave, so what the 5.6 weeks, and then we've got pay. So we are when we are doing our calculations for holiday, we're actually doing two separate calculations. And So how has this all got so muddled? What went wrong? The Harpur case. So first of all, we'll go over the facts. So what happened in Harpur? So Mrs. Brazel, I think I want to pronounce it Brazel, was a music teacher. She was a term time worker, but she was engaged in a full year permanent contract. She generally worked between 32 and 35 hours per week. She wasn't guaranteed work, and she was paid by the hour. And the way that the school up to 2011 used to calculate her holidays was that they would pay her at the end of each term. So they looked at it on the basis that there's three terms in a year. So when they got to the end of the term, they'd pay her a lump sum for the holidays. In this case, we're not arguing about actual leave. She received 5.6 weeks leave a year. That wasn't in dispute because she had all the school holidays off. So the leave element wasn't an issue in this case. So what they did up to 2011 is they take an average back of the last 12 weeks that she'd worked to get her average pay. And then they took the 5.6 weeks holiday that she was entitled to, divided it by 3, because as I said, they were doing 3 equal payments throughout the year at the end of terms. So that gave us 1.87 weeks. So they took the average pay for pay that they'd calculated over that 12 weeks, times it by 1.87, and then paid her in a lump sum. They then, in 2011, changed their approach. And what they did was now they looked at the hours that she worked each week, which obviously varied, and they paid her 12.07% of pay based on what she had worked. And again, paid in a lump sum at the end of the year. At the time, this was in accordance with the ACAS guidance. So ACAS did publish guidance that supported this method. So it wasn't just something that they plucked out of thin air. They thought that they were doing the right thing. What this actually led to, though, was a deduction in Mrs. Brazel's holiday pay, and she therefore brought a claim for unlawful deduction of wages on the basis that her holiday calculation should revert back to the 12-week method and not the 12.07%, which she argued she was receiving less money. At the first opportunity that this was heard, this is the employment tribunal, the judge took the trust side. They supported the school in the payments and said, Mrs. Brazel, you are wrong. The school are entitled to use 12.07%. We hoped that was the end of it. It was not. So what happened next, we saw some appeals, and it went to the Employment Appeal Tribunal, and they found that the working time regs did not support the prorating of holiday on the 12.07% basis. The trust were wrong. So the Court of Appeal picked this up, and the Court of Appeal agreed with the Employment Appeal Tribunal and again found that the working time regulations didn't allow for the 12.07% approach. And one of the questions that they then had to deal with was, well, does this mean then that part-time workers might end up receiving a higher proportion of pay compared with a full-time worker? And the Court of Appeal found that all our regulations say that you can't put part-time workers at a disadvantage, but it doesn't say that we can't treat them more favourably. And we don't have regulations that say that you can't treat part-time workers better than full-time. So we went up to the Supreme Court now, because obviously this is a big deal. This is going to affect lots of businesses, lots of companies. We needed a final answer, and the Supreme Court found in favour of Mrs. Brazel, and they agreed with the Employment Appeal Tribunal and the Court of Appeals approach. They found that there was nothing in the legislation to support the 12.0% of hours to be paid. And instead, they said the correct approach was the calendar week method, which involved going back over the last, at the time it was 12 weeks. At the last 12 weeks, taking that percentage, taking that average and applying it to 5.6 weeks worth of pay. As I said, in this case, the actual leave element wasn't argued, albeit the trust did put forward a middle ground approach where they wanted to say, well, she doesn't work all year, she only works, as I said, maybe like 35 weeks out of the year, so maybe we portion it out on that way. So they wanted a middle ground, which again the tribunal and the appeal tribunal, the Court of Appeal and the Supreme Court rejected. They said no, she is engaged on a contract that spans the whole year, and therefore she has 5.6 weeks of pay because the contract is for that full leave year. So who's this going to apply to? Who's this going to affect? The key people this is going to impact are 0-hour workers or employees. So just again, I just want to be clear, holiday pay applies to workers and employees. So it doesn't matter if you class them as casual workers, agency workers, unless they are self-employed, they are entitled to holiday pay. So we're not debating the status here. It applies to everyone. So 0-hour workers, so those that you might engage 1 week, you might offer them 30 hours, there might be nothing available the next week, you might offer them a few hours the week after, they might say, I'm sorry, I'm busy, then they might do another few weeks where they'll do up to 30 hours with you. So those types of workers, they're common across so many sectors, and they play quite a key part in our industries. Part-time workers, again, who may not work consistent hours each week, it's going to apply to. So they may work more hours 1 week, less hours the next, may even miss some weeks. Casual workers, so again, we're coming into like casual agency worker areas. Term time workers or employees. Agency workers. So agency workers, I do just want to say a little bit about. So agency workers, it will only apply to an agency worker if they have an overarching contract. That means that they are still engaged with the business between assignments, or with the umbrella company between assignments. It won't apply to them. So if you read further down, obviously it applies to people that work some weeks that don't, or anyone where you pay holiday based on number of hours worked. But the key line here at the bottom is all of the above on permanent or open-ended contracts. So an agency worker, if you have very clear assignments, and at the end of each assignment, the engagement is terminated, you pay the holiday, there is then a gap until they start a new assignment, but there is no overarching contract, then they won't be included in this. However, this could be something that we see argued. I wouldn't like to give you a definite on that, because I don't think Harpur Trust saw this case come in, and I think it would be very naive of us now to think that this is the end of the story, because there is still some some loopholes here, I think, that they might want to plug. So again, to summarize, anyone that is on an open-ended permanent contract that doesn't work regular hours for you. So that is who it applies to. So for these workers, how should we now calculate a holiday entitlement? So let's look at the BEIS guidance. So this is on the government website, and you're going to be hoping here that there's going to be a really detailed document that's going to tell you exactly what to do. This is it. It's a paragraph, and what the paragraph says is that employers may wish to calculate average days or hours worked each week based on a representative period, although the regulations do not expressly provide for this. In all cases, employers must ensure that each worker receives at least 5.6 weeks annual leave per year. That's it. That's what we're working with, and that's all we've got. It's poor, to say the least. So, looking at their guidance on what we're now going to be doing, and have in mind that even they're acknowledging that the regulations don't actually support this, but because it's coming from the government, I'm hoping that they're going to stand by the advice that they're giving employers. The first thing we're going to do, we're going to apply a representative period. So you will look at that employee, and you'll you need to then go back and work out how many hours or days they have worked each week over that period. It doesn't specify what that period should be. That is up to you to consider what would be the best period, the most that would be most reflective of that employee's hours. So that could be 12 weeks, it could be 26 weeks, it could be a whole year. It's purely looking at that individual employee and what and how they have worked for you. Then we need to work out what a proportion of a week each day or hour represents. So I'm going to give you some examples, and we will take it a bit slow. So don't worry, because I've got to admit, I've been working on this all morning, and now I'm looking at this again going, oh, maths, it goes in one ear and out the other. But essentially what you're doing is you're looking back and saying, right, if that employee has worked an average of 10 hours a week, then to work out what proportion of a week's holiday they would take, for example, 10 hours, we'd do 1 divided by 10, so we get 0.1, and therefore that would mean that every hour that they take for holiday we would deduct 0.1 weeks off the 5.6. I'm going to show you what that looks like, don't worry. Then we do the calculation for the week's pay. So again, stressing that working out entitlement and working out pay are 2 separate calculations. So then we have to go back over the 52 weeks and apply this to the proportion of the time being taken as holiday. So again, when we're going back over 52 weeks, a reminder, we're ignoring any weeks where there has been no pay received or statutory payments, because what the law is saying is that they are entitled to a fair week's pay, their usual week's pay. So the bad news is this would need to be done. Oh God, my typos in this are terrible. Yeah, every time the worker takes leave. So what this doesn't help us do is work out how much in advance, how much leave someone's allowed to take. That's the answer I can't give you today. But what this is saying is, well, if we're saying that everyone's entitled to 5.6 weeks, this is giving us a way to at least deduct from that 5.6 and work out how much holiday they're taking, when they take a day, when they take an hour, and also how much they should be paid. So as you can see, it's not a straightforward option. It's not great. So what else can we do? We can look at saying our employees must take leave in blocks of 1 week. Obviously that would make life easier, because then we just have to go back, do the 52 week average for pay, and apply that pay to every 1 week that employee takes as holiday. And that way as well, we ensure that they take 5.6 weeks. Practically though, is this going to work for employees? Is it going to work for your business? There's very few people I know that take their holidays in 1 week blocks. And then what do you do about the 0.6 week? It's not helpful, I don't think, but it might work for your business, it might not. Another option, which again is not tested, but in theory could work. So this is a bit of a theoretical option that I said in practice, would this work for everyone? We would assign 0.2 weeks to each day of holiday. So this is looking at days. So we'd be requiring an employee to take holidays in days, not hours. And every day they take, we would say that represents 0.2 weeks of holiday. So we deduct that from the 5.6, and then we would pay them 20% of a week's pay. So what I'm looking at is you're basically treating someone that works 5 days a week the same as someone that works 2 days, and that's where you're getting 0.2 from. So 1 day being 0.2 of a 5-day week, obviously 20% being 1 day's pay of a 5-day week. So you still need to again go back and do your 52 week average, but again this means that you are giving everyone 28 days holiday. It's fair, it's very fair, but you are most certainly treating part-time workers more favorably than you are full-time workers. So how that would sit with your workforce, I don't know, but it would at least ensure that everyone's getting 5.6 weeks of leave and you are paying properly as well. So it's just a suggestion. Again, how that would play out in your business, I don't know. So let's have a look at some holidays, some examples. So this is going back to the way that the government are now telling us to do it. So we've got the example of Joe, 0-hour worker, works variable hours each week, and some weeks doesn't work at all. So maybe your typical student who does more hours one week than the next. So first of all, we're going to apply a representative period. In this case, I've applied a 12-week period. I've gone back and looked at what Joe has worked over the 12 weeks. And this is looking at a payment in hours as well. So I've done 2 examples. I've split one to hours, one to days. So your payment in hours, what I would be looking at doing would be saying, right, over the last 12 weeks, how many hours per week has he worked? Divide that by 12. Or if there's weeks where he hasn't worked, I'd go back even further and still do the division by 12. So I've calculated he's on average, he's worked 10 hours per week. So I then need to look at, right, every hour Joe takes as a holiday, what would that reduce his entitlement by? And in this case, it would be 0.1. So I said we've got 1 divided by 10 hours. So the average number of hours per week that he works gives us 0.1. I would then apply, so that's the amount of leave he's taken off his 5.6 for every hour that he takes. Then I'd pay him 10% of a week's pay taken over an average of the last 52 weeks. So I say, does it look simple? Does it not? What this means is you are doing a calculation every time someone takes holiday, particularly if they're taking it in hours. You are needing specific amounts from them of, right, how many hours are you taking? How many do you want to take? I'm not saying this is perfect, but this is what we've got. And even I'm struggling to come up with other suggestions and ideas as to how to make this easier for you guys. So that's the example in hours. The example in days, again, works pretty similar. So again, we're looking back over 12 weeks and we're seeing on average how many days is he working. So this is regardless of how many hours he works on those days, we're looking at how many days. And in this case, we've looked back over those 12 weeks, excluding the weeks that it doesn't work, and we decided that actually he only on average works 2 days per week. When you're doing your averages, I would say usual rules on averages. If it's 0.5 or over, you need to round up. If it's 0.4 downwards, I think you'd be safe to round down, or you do it as 0.5 if you're able to. So in this case, because he works on average 2 days a week, we would be saying that for every day holiday that he takes, he would lose 0.5 of his holiday entitlement. So for every day he takes, he's actually losing half a week off his 5.6. And we're doing that, that's the 1 divided by the 2. And again, we are looking at, well, his 1 day represents 50% of his working time. So we go back over his 52 weeks, take his average pay and pay him 50% of a week's pay for every day that he takes. So that's the example as it works in days. So can I still use 12.07%? Big question. Firstly, just a very quick overview of where 12.07% comes from. As I said, it was actually originally recommended by ACAS, and where it comes from is you're entitled to 5.6 weeks. So you take that off of your 52 weeks, that leaves you with 46.4, and then you look at 5.6 weeks as a percentage of the 46.4. If I've said that the right way, that's how we get 12.07%. Feel free to play on your calculator, it does work out, but that's where 12.07% comes from. And as I said, for a long time, it's been deemed a very fair way of calculating. So yeah, your example there, someone who works 100 hours a month, pays £10 an hour, just because it's nice, easy numbers, they would therefore be entitled to 12.07 hours of holiday, and you would pay them £120.70 if you times that by your 10. So that's how it's been worked out by lots of different industries over the years. So what difference does it actually make? So what I did, I've taken the calculations from the Harpur case. This is what they used in the case to work out exactly what Mrs. Brazel had lost. So by her calculations, she should have received £687.26. Using the 12.07% method, what she was actually receiving when they changed it was £452.20. So actually that is quite a big difference. And you can see why now, as a worker who had previously been paid at the higher rate, would suddenly become very disgruntled, because that is a noticeable difference. One thing I will add, though, is that I've done quite a few calculations now the last few weeks for our clients. And some of the clients, when I'm doing the calculations, the employees are still coming out better off on the 12.07%. It's not always going to be skewed in this way. So my advice to them has been, keep it under review. Generally, the workers that are less affected are those that do work regular hours each week. The ones where it's more favourable to do the calendar week method are generally the ones that have got gaps and don't work certain weeks. So those clients, what they're going to continue to do is that as long as they are carrying on working regular hours each week, they're going to carry on with a 12.07% on the basis that actually they're receiving more than what they would on the calendar week method. Multiple reasons for that. One, don't want disgruntled employees, but also they're looking at it as the extra money that they're paying them via the percentage method is worth it in terms of the hassle it would cause them to start calculating it in a different way. So should you stop using 12.0%, 7%? There's no legal basis to continue to use it. Any future cases are likely to take the same approach. And also it is difficult to track how many weeks someone has taken when they are using 12.07%. So really, my advice to you be, you shouldn't be using it, but it's up to you guys what you want to do and what you think is the most fair way of dealing with this for your employees. Can I still prorate holidays for part-time workers on fixed hours? You will be relieved to know that you can. So as long as they work fixed hours, that's fine, because a week's leave is personal to that employee. It doesn't mean 5 days. A week's leave means however many days that employee usually works. So we've got Joe again, he's working 4 days, so he is entitled to either 4.5 weeks holiday or 22.5 days if he works 4 days. So yeah, this decision only applies to those working irregular patterns or inconsistently throughout the year. Does this decision apply to contractual holiday entitlement above the statutory 5.6 weeks? So lots of employers will pay more than the 5.6 weeks, which converts generally to 28 days. Most common ones I see is like 25 plus 8, so actually that's 33 days. What do you have to apply this to those additional days? And the answer is no. You can actually decide what you want to do with those extra leave days. So contractual leave, you could decide, for example, you wanted to carry on applying the 12.07%, or you may say that you'll still look at it from the accrual point, but in terms of working out pay, you are going to take into account weeks that they don't work in order to bring down that payment as well. Be careful, it may carry some risk doing that. Again, you need to look at the demographics of your workforce just to make sure, for example, that women aren't going to be more disadvantaged by this than others, because obviously that could lead to things like sex discrimination. And again, part-time workers aren't disadvantaged, because as we've seen, we can treat them more favourably, but we can't treat them less favourably. Can I still pay rolled up holiday pay? So rolled up holiday pay means when you pay an enhanced hourly rate, which includes an element for holidays. This has never been allowed, so we shouldn't be doing it anyway. But well, I say never been, certainly whilst I've been practicing, which is quite a while now, it's not been allowed. So the answer to that is no, you shouldn't be using it. However, if you do that and you think, I don't want to change my ways, the only bit of comfort I can give you is that, as provided that you are very clear when you set out the the hourly rate, that part of that includes holiday and the percentage that it includes as holiday, then if you do end up in a tribunal for failing to honour the 5.6 weeks, then you can at least argue that you've paid some of that bill. So they will take into account, they'll offset what you've paid on the additional, provided it's clearly set out. I don't think judges are going to like it. The judges I've seen over the years that I've dealt with this have definitely not liked it. But again, it's up to you how you deal with your holidays. So, top tips and final thoughts. This is going to have a bigger impact on workers who work for shorter periods over the course of a year with more gaps. So I put here the exam invigilator example because this was one that was actually given in the tribunal when they were discussing the Harpur case, and I just think it's absolutely bizarre. So the example that they gave was an exam invigilator who is only contracted to 3 weeks a year. But it's an open-ended contract. They return year on year under the same one, so the assignment is never terminated. That 3 weeks, they'll do a 40-hour week, so they'll do three weeks, 40 hours full-time. Under this ruling, that would now mean that they're entitled to 5.6 weeks pay. And if you look back at the average, so that would be 40 hours. So they're entitled to 5.6 weeks at 40 hours for 3 weeks pay. They're entitled to nearly twice as much holiday pay as they are to what they have worked. It is bizarre. But I think the judge's approach to this is that will only apply to a very small minority. So the other things we need to think about is, right, if we have got this wrong, what are our risks? So generally the rule is that an employee has a worker has 3 months from the last date of the unlawful deduction to start a claims process against you. If there has been longer than 3 months in between between an unlawful deduction, it's arguable that that will then stop the back pay, so that the claim would only start from the last date of the unlawful deduction within the 3-month period, provided that it's always been rolling on. They can claim up to 2 years of back pay. The advice that I've been reading on it is that we shouldn't be relying on that 3-month break, because it may be again something that's up for argument. Just because a worker has gone 3 months and 1 week without an unlawful deduction, does that mean then that they're entitled to forfeit the last 18 months of underpayments? So I think it's up for argument. If you've done your calculations and you find that you do have liabilities, as I said, we can go back up to 2 years for back payments. The key part is we'll work out what your liabilities are, and then you may want to start some consultations with your employees to reach a compromise. We can help you do that. We can help you assess what the risks are, and we can help you do some calculations on it as well. So going forward then, how are you going to avoid this? I think it's going to be the use of genuine fixed term contracts could avoid this. So if you are setting actual assignments that start on one day, end in another, you're not then engaging that person a few days later to do something else. So there's got to be a genuine break in between those employment spells. Then you can still pay holiday that's accrued for that proportion of the year, because it's not, you then don't have a contract that runs throughout the year. It runs for a set period. You can prorate the holiday, and you can pay just what's due, but still using the calendar week method of going back and averaging out the pay. Same as some may want to consider using self-employed contracts more, where there is no holiday pay, but again, we're looking at how genuine these appointments are. You could consider removing your 0-hour workers and putting them all on a salary. for a low number of hours, and what that could do then is minimize the risks of the difference between the pay, basically. So that's another way of looking at this. But again, we need to be clear on creating genuine relationships. Judges will see through things that have been set up just to try and avoid things like holiday pay, but also you find that self-employed contracts are sometimes used to avoid things like pensions as well. So judges take a dim view on setups that, where all the paperwork might look, very kosher, but the reality of the situation is different. They will always side on the reality. So my final thought on this is, do I think this is fair? No. Do I think that this is an absolutely absurd result? Yes, I do. What's going to change? I don't think a lot's going to change. Basically, what the courts have said is this is Parliament's fault. So the legislation that we have doesn't allow for the flexibility that employers need, and therefore this is Parliament's fault. So the courts are going to keep batting it back to Parliament. Are Parliament going to intervene with any new legislation? I don't know. I haven't asked Liz yet. I don't know if it's on her agenda. I doubt it. But we've just got to wait and see. But this is what we've been left with now. So that's all my thoughts on this today. I've put up here a QR code for if you do want any other help, advice, support, you want to look at our services, you want to talk this through, give that code a quick scan. It'll take you to our website. You'll be lots of information there and the support that we can provide you with. So please do have a visit to that or give us a call. Happy to discuss things with you. And then, finally, it's about keeping in touch with us. So please sign up to our newsletters, follow us on social media, and you'll always receive the most up-to-date information. Right, and I'll put the QR code back up while we have a look and see, have we got any questions? Anything anyone wants to ask?
There hasn't been any questions, Lynn, so you must have, it was very well explained, so I don't know, either everyone's really confused.
I think everyone's really confused. Like I said, I've spent hours on this. I'm still not 100% comfortable. So I read it sometimes and think, oh yeah, I've got it. And then I read it again and I think this is just stupid. I really do. So I wish I could be some more supportive and tell you that, we're all going to be fine. Actually, I think this is going to be a real roller coaster for companies and a complete admin nightmare. Like, how much time are we all now going to have to spend calculating holidays? It's just ridiculous. So one last opportunity. Anyone want to ask me anything?
We have just had a question from
right. So question: if we use my HR toolkit, will this work it out for us? I don't know, because we also have HR toolkit. I will be interested to see if they are going to update it. I think I will be emailing them today to see what they're doing and what their what their processes are for this. So unfortunately, Heather, I don't know. I hope. I mean, it'd be nice if they'd have bobbed on today, but maybe they're taking their advice elsewhere. I hope they are, though.
There's been a question from Lizzie as well, Lindsay. Does all this only apply to employees who have worked for more than 2 years?
This applies to employees right from day one. So anyone who starts with you right from day one is entitled to holiday pay. So it's not a 2-year rule, unfortunately. And again, just to stress, it's workers and employees. So casual workers, if anything, are more affected by this than those who you've got on as regular employees with regular hours. Right. Anything else anyone wants to ask me? Okay. So so we've got a question here. So if an employee works irregular hours but works 52 weeks per year, would using the 12.07% method still be okay? So I did a calculation for one of our clients that was similar to this, and I found that 12.07% paid more than the calendar week method. However, what this doesn't do is provide any evidence that that employee has been entitled to 5.6 weeks of leave, which is obviously a right under the working time regulation. So again, pay and leave are two separate things. We need to be encouraging our employees to take leave. And again, judges take a very dim view if they are discouraged, and paying the 12.07% would discourage them from taking actual time off away from the business. So I do think there certainly risks to carry on using that method. Pay wise, will your employees be at a disadvantage? Maybe not. Do your calculations, have a see. From a leave perspective though, are you still making sure that they are taking the right amount of time off? Hope that answers that question. Anything else? No, you're all going to go away now with a big headache. All going away going, oh my god, what am I going to do? I do think yeah, the HR toolkit point, if you are using software, I'm expecting these software providers to have to start taking this into consideration, because they can't just say, oh, we'll only provide your HR support for your full-time or regular working part-time workers. You know, that if they're going to provide the software, it needs to cater for all your employees and workers with the right ways of calculating. So maybe that will make life easier. I don't think they're going to know what to do with it though, at least for quite a while. Okay. Right then, if that is the end of questions, as I said, I think Ellie has posted both mine and her email address in, so please feel free to bob us an email afterwards. Also, in terms of events going forward, we've got some great stuff coming up. We've got our social, which is next week. So if you want to do a little bit of networking in Sheffield, please come along to that. You'll find details on Eventbrite. Same as again in a week or two's time. What else have we got? We've got women lawyers coming up. So any women lawyers in the group today, please come and join our networking for that. And then we carry on with our HR exchange program as well, which is also our free training, and the next one's discrimination. I know Ellie is very busy as well delivering our paid training courses. They are great value for money. You get so much out of them. We have put so much time and effort into those courses to make sure that they are everything that you need. So have a look at our paid training. Also, we've recently been approved as a provider for Skills Bank. So again, if you're after specific training for your company, please have a look at Skills Bank, because it means that you could be receiving between 40 and 60% off of your training costs with us. If there are any courses that we've got a big list of courses that we can offer, but if there's anything that you think, oh, I want something more bespoke for my business, you can still get that through Skills Bank. Speak to us, we can help you fill out the forms. I just think it's a great way now to start upskilling your workforce at a lower cost. So yeah, please do have a look at that and get in touch if you want any more information on any of our courses or Skills Bank. Okay then, so I think that's everything today. Thank you everyone for